Sinä.
Businesses impact human rights wherever and however they operate. These impacts can be positive or they can be negative. These days, companies are global, and that means their impacts are too. Companies operate in poor countries and post-conflict countries, in countries where the local government is unable or unwilling to enforce its own laws. With all this complexity, it's not always clear who's responsible for preventing companies from violating human rights. Is it the company's fault for paying less than a living wage? Or is it the government's fault for setting the minimum wage below the poverty line? Victims of corporate human rights abuses find themselves trapped between two actors who have no interest in making things right. In 2011, the United Nations issued a set of principles that define the responsibilities of governments and businesses for solving this dilemma. So what do these principles say? There's three pillars. The first says that governments have to make sure that businesses don't violate anyone's human rights. That means passing laws that prevent human rights violations, but also making sure these laws are implemented. Some of the world's largest multinational corporations are owned and operated by states. The guiding principles say that governments have to prevent human rights violations by businesses, even if the state itself is acting like one. The second pillar says that businesses have to refrain from violating human rights wherever and however they do business. That means it's not enough for companies to simply follow the law where they operate, or to audit a few of their suppliers. Even in countries where the government doesn't take up its own duty, companies have to know their human rights impacts and take concrete steps to improve them. The guiding principles don't offer any loopholes. Companies are responsible for all human rights. Doing things like building a school or digging a well doesn't get them out of their basic responsibility not to make their workers and communities worse off. Companies have to perform human rights due diligence. That means talking to the people whose lives they might be affecting. Like the government responsibility, respecting human rights isn't a switch that companies can turn on and off. It's a continuous process. The third pillar of the guiding principles is about what happens when something goes wrong. If a company abuses human rights, governments have to make sure that the court system or some other legitimate process allows the victims to file a complaint and that complaint is investigated and settled. Companies have this obligation too. Part of human rights due diligence is allowing people affected by the company to file grievances and participating in processes to make them right. Whatever route they choose, remedy mechanisms should fit with the effectiveness criteria defined by the guiding principles. If the complaint system is slow, or it costs too much money, or it's far away, it doesn't count. So that's what the guiding principles on business and human rights say. So why are they important? First, the principles were unanimously approved by the UN Human Rights Council. Since then, they've been endorsed by governments and business actors all over the world. Before, we argued over who was responsible for preventing human rights abuses by companies. Thanks to the UN Guiding Principles, we know who's responsible. That means that instead of arguing over the rules, we can get to work implementing them.
Vuorossa on asiantuntija Adriana Espinosan puheenvuoro. Hän tulee European Coalition for Corporate Justiceista Brysselistä. Policy Officer Adriana Espinosa, welcome to the stage. You have a presentation coming up.
Yes.
We have the special stage for you. Before that, quick question. Why have these questions of companies, corporations and human rights risen just lately?
Yes, hyvää huomenta, and that's all the Finnish I can speak, so apologies for making my presentation in English. And because of this language issue, I would like, before I respond to your question, to make a very short definition. So you will hear me today speaking a lot about human rights due diligence. So when I speak about human rights due diligence, I mean the process that allows a company to identify and prevent its human rights impacts that are linked to the business operations. So I think the director of trade may reference also, and the other people from companies. So yes, why? We have been seeing lately a lot of discussions and even legislative processes and legislations in Europe that refer to the notion of human rights due diligence. This is becoming a trend, the adoption and discussion of human rights due diligence legislation. Why is this so? Well, there are several factors. One of them is the adoption of the UNGPs in 2011. So the UNGPs established the concept of human rights diligence as the process that allows a company to respect human rights. So everybody started to speak about human rights due diligence. But also, there were already many voluntary frameworks and codes of conduct that made use of the notion of due diligence or were related to due diligence. So companies and the public knew about this thing. States also have been using, during many, many years, the notion of due diligence in different areas of law, like environmental law, anti-corruption, consumers protection. So this concept was very familiar. So in the last year, what has happened is that civil society, companies, and also decision makers, governments have realized that all those voluntary measures are good, but they are not enough in order to make business really undertake the responsibility to respect human rights. So there have been discussions around this, and there has been an acceptance, especially by companies that before were happy with only voluntary measures, and now they are realizing that we need a binding framework. And also lastly, there have been some developments in the area of transparency and reporting, and we have seen that this is good and is essential, but also is not enough. So the need of these binding substantive norms has appeared as something very important lately.
Thank you. Before going deeper and into your presentation, I'll remind people that before the break, we'll have time for a couple of questions from the audience. So while she's representing her show, if there's something you want to ask, make a mental note or something. Now, please, Adriana Espinosa.
Thank you very much. So I think okay, thank you very much, yes. So this is what I want to talk to you about today. This is the rise of this human rights due diligence legislation in Europe. And as I said, we have already one law in force, which is the French duty of vigilance law, which was adopted in France in 2017. We have also legislative processes going on to adopt different legislations in Switzerland, in the Netherlands, some initiative also in Austria. And we have governments that have committed to consider human rights due diligence legislation in Italy, in Germany, and more civil society and more companies calling for it around the world. I explained before in my introduction why these factors were, why we are at this moment now. And what I want to tell you today is, very importantly, how these laws work. So what these laws are asking companies to do, companies present here. So how can civil society understand what these laws require? Because I cannot speak about everything, because I don't have time, and you will be so bored that you will fall asleep. I will use 3 examples. So I will speak about the French duty of vigilance law. I will also speak about the Swiss Responsible Business Initiative that is being discussed in Switzerland currently, as examples of this human rights due diligence legislation. I will also refer later to the UK Modern Slavery Act. That is an act that was adopted in 2015, and it's very important, but it requires only a disclosure reporting requirement from companies. So you will see the difference. And if you have not left the room by then, I will finalize with a short conclusion, which is for me important to express. And it is that we think that mandatory human rights due diligence legislation is a feasible and very practical way to foster business respect for human rights. So that's the point I hope I will reach today. Bear with me if there are some technical details, because I have to refer to them, but I'm happy to answer any question. So, okay, we have the French devoir de vigilance law, duty of vigilance law. What does it require from French companies? So it imposes over large French companies an obligation which is called duty of vigilance, devoir de vigilance. What does it consist of? Well, the duty of vigilance requires companies to take all necessary measures in order to identify and take action concerning the risks and severe impacts to the human rights, health, safety, and environment that are linked to the company's business operations. So to the company's own activities, to the activities of companies the main company controls, and to the activities of those subcontractors and suppliers with whom there is an established commercial relationship. That's a technical reference that the law makes. So basically, companies have to undertake human rights due diligence. And more in detail, the law provides more details. what are these duty of vigilance obligations? There are three main obligations and three main steps, let's say, three main clear obligations. First, the company has to design and establish a vigilance plan. So this plan contains measures in order to identify and prevent those human rights impacts, okay? But only having a plan is not enough to comply, to fulfill the law. The company has to effectively implement the plan. You have to have a plan, you have to put it into practice. And finally, the company has, or all companies covered have to publish the plan and the report on how the plan has been effectively implemented in the company's annual financial report. And they have to also to publish it in a link to their websites, okay? So you must have a plan, you must put it into practice, and you must publish the results of the plan and of the efficiency of the plan. So there is a transparency requirement here. And something which is very important with the French law is that if you look at some of the basic requirements that the plan must contain, you may find many similarities to the United Nations Guiding Principles. And this is because the French law is very inspired in the UNGPs. The drafters of the law intended to implement the UNGPs into the legal framework of France. So companies have to make this plan, looking at the measures to identify, etc., and have this plan in place and publish. What happens if the company hasn't fulfilled or meets its duties? So the law has two main enforcement mechanisms, and they are judicial mechanisms. So the law is implemented in courts. That's the way the drafters chose. And there are two main ways for this. The first one is called formal notice in order to comply. So any person with standing, it can be an NGO, it can be a trade union, it can be a victim in a third country, a person affected by the company's activities, they can ask a judge in France to order the company to comply with these obligations. So to publish the plan, to implement it better, etc. If the company doesn't comply with the order, it can be subject to penalty payments until the company does its duty. That's the first resource. In worst case scenario, there is civil liability. So companies can be liable for those harm, those damage that could have been prevented if the company had taken due diligence. So a person, a victim in a third country can go to a French court and can seek compensation. This is civil law, so can seek compensation remedy if the company hasn't done due diligence. Something very important here. The company will not be liable for every harm or damage that is caused in their business operations, only when the harm could have been prevented with due diligence, or only if, even with due diligence, the harm could not have been prevented. Only in those cases, the company will be liable. And the victim, or the alleged victim, has to prove the harm, has to prove that the company didn't comply, didn't fulfill its obligations, and has to prove the causal link. So there is a burden of proof which relies on the victim, as in normal cases. So this is the French law. Already in force. Companies have started to publish their vigilance plans already, by 2018, and there will not be any civil case until 2020. Well, if there are. So now let's go to the Swiss one. The Swiss model is very similar, but it's not identical. And I just want to mention something in the matter of context. So we have two things going on in Switzerland now. One is the Responsible Business Initiative. The Responsible Business Initiative is a popular initiative that seeks to change the constitution, the federal constitution in Switzerland, in order to introduce in the constitution this corporate responsibility to respect human rights via human rights due diligence. It's a popular initiative, it shall be voted in referendum, and it's going on, it's moving on. But in the process of this RBI, the Parliament, it's 2018. So the Parliament adopted in 2018 a counter-proposal. So it's not the RBI, it's not the popular initiative, but it's very similar. And it keeps the main elements, so human rights due diligence and civil liability for serious human rights abuses. So I'm going to explain the Responsible Business Initiative because it's very similar, and then you can ask me questions if you have doubts about the differences between these two. You will find so many similarities. So the Responsible Business Initiative requires companies to undertake human rights due diligence, so to respect human rights and environmental law by undertaking human rights due diligence. That is, to take reasonable measures in order to identify, take action, and account for their impacts to the human rights and the environment, those impacts which are linked to the company's supply chain. So that's the basic notion of human rights due diligence. So the Responsible Business Initiative applies to all companies in Switzerland, I mean, if it is adopted, but small and medium enterprises operating in low-risk countries would be exempted. The counter-proposal by the Parliament would only apply to large Swiss companies with certain value of business, and large companies operating in low-risk countries would be exempted. So you already can see some of the differences. So this is the basic obligation for Swiss companies. Again, human rights due diligence. What happens if the company doesn't fulfill or meet its obligations? There are two. Again, this model, as the previous one, relies on enforcement via courts, so judicial enforcement mechanisms. And there are two basic kind of liability, responsibility. First of all, this is the same as the French one. The company, the parent company in Switzerland, would be liable for the damage that has occurred or caused by activities of its suppliers or companies down in the supply chains when the parent company didn't take all measures in order to prevent human rights. And in this case, it can be, like in the French one, it can be damaged by a supplier. There is no relationship of control between the parent company and the supplier. So if the parent company took all the measures that it had to take to prevent this harm, but still the harm occurred, the company will not be liable. But, and this is a thing which is very different in the Responsible Business Initiative, what happens with companies that are controlled by the parent company, so a subsidiary fully controlled by the parent company? In this case, the parent company would be automatically liable for the harm caused by the subsidiary unless the parent company proves that it took all due diligence. So in the previous cases, the main difference is that in the previous cases, the victim had to prove that the company failed to comply with its obligations. In the case of the Responsible Business Initiative, when there is a notion of a relationship of control, the company has to prove that it met with all this obligation. So bear with me. If there are any questions, we can solve them later. These are the two basics human rights due diligence legislation. But so what I want to make clear here is that human rights due diligence, what requires from companies is that they take reasonable care when they conduct their business operations in order to avoid causing unfair harm to third parties. So it's the notion of reasonable care, duty of care, acting with reasonable care. So it's something which is very familiar for many, many people and lawyers and judges. It's a preventive law, and I will go to that later. But worst case scenarios, victims can have a window open to access justice, to obtain remedy if the company didn't meet with these obligations. But as I said, companies are not liable for all damage caused by the activities, only for this damage which could have been prevented. Okay? So this is human rights due diligence into practice. And with this example here is the UK Modern Slavery Act. I don't know if you are familiar with this law. This was adopted in 2015. It was actually indeed a groundbreaking law because it addressed modern slavery that I think it has been mentioned before that it's very important and it exists in our supply chains. And the law itself included a lot of elements of criminal law, etc., for directors, etc. So it was a very complete one. But concerning business operations and supply chain, it contained not only, a provision which was called Transparency in Supply Chains provision. And this provision required companies in the UK to publish every year an annual modern slavery and human trafficking statement declaring the steps that the company has undertaken to prevent modern slavery from taking place in the supply chains. So that is the main difference. The UK law only required companies to publish a statement declaring what steps you have taken in order to prevent this harm from happening. If you have taken no steps, you can say, I took no steps. I considered it wasn't necessary. Okay, that is complying with the law. The statement would have to be signed by directors. So if you lie intentionally, there is some responsibility for the director of the company. But the law doesn't require companies to really take those measures, because companies have just to be transparent with what they do. Is it more or less clear? So, yes, so this is the difference between one framework and the other framework. And I don't know how much time I have left, but I think I'm doing more or less okay. So, yeah, great. So I'm going to finish with the conclusion that I wanted to express today. And this is why we think, and I'm speaking on behalf of a coalition that gathers more than 200 civil society organizations in Europe, including FinWatch here. Yes, so why we think that human rights due diligence legislation is a kind of legislation that is very feasible and practical to promote better business behavior. And there are three main basic reasons. The first reason, human rights due diligence is a familiar concept to companies and to governments. I said that. Companies already know there are so many standards on human rights due diligence. We have the OECD Responsible Business Conduct Guidance. We have the UNGPs. There are sector-specific guidance. So there are so many voluntary standards and guidance that talk about human rights due diligence. And also companies conduct due diligence in their day-to-day business. They do financial risk assessment, financial risk management. So they know how to risk management. But in this case, human rights due diligence requires companies to look for the risks to the society, to the people affected by their activities, not to the company itself. So it's a very familiar notion for companies. It is also a very familiar notion for governments. As I said before, governments had made use of due diligence to make companies meet certain standards already, environmental law, anti-corruption, etc., etc. So it's a very familiar notion. Secondly, human rights due diligence legislation would indeed level the playing field for companies. We have been seeing here examples of companies that are already doing their best. So they have some ethical commitment, they have some view, and they think, I have to promote and respect human rights in my supply chains. And we have many companies doing that. Not enough companies, otherwise we wouldn't be here, right? But we have many companies doing that. And they have to, on the first hand, choose among so many different standards and variety standards and documents and etc. And they have to figure out in their minds what they have to do. There is no legal requirement telling them what to do. And on the other hand, they have to compete with companies which are not required to do anything. So there is a certain disadvantage there. So this would level the playing field for companies by establishing in law certain requirements that companies have to meet. And finally, it is a very practical way because it has a very strong preventive focus. So very important here, the main objective of human rights due diligence law is not to punish, is to prevent, by giving companies a tool to identify and prevent their human rights impacts in the supply chain. So in the long term, it's also good for the company. If you have only a short-term minded, you will not realize that. But in the long term, it increases your sustainability in the supply chain. So it is good for companies, it is good for the government, and it is good for the people because you prevent the harm to them, of course. But also, if there is harm because the company didn't want to do their best to take reasonable measures, victims can have access to remedy, to court, in the worst case scenario. So that's why we think human rights due diligence is very important. We have already seen that the fact that these laws are being discussed in different countries have also made companies more aware of this. And there is already a growing willingness by companies to understand, but what is this of due diligence? What did this law require from me? So the dialogue has already started in France, of course, but in Switzerland, in the Netherlands. ECG organized a webinar on legal elements of this law, and it was only for civil society organizations, but we had so many requests by company to join these webinars. Companies from countries where even this law is not accepted, because they thought, maybe this law will come to my country, so I better know. So we have already seen the change taking place, and well, I hope this has been more or less clear, and I'm happy to answer your questions. Thank you very much. Thank you.
Thank you, Adriana. Please. We'll stay here for a couple of questions.
Yes.
There's about 5 minutes left. Due diligence, huolellisuusvelvoite. Just a reminder. Questions? There's first one.
Outi Mikkonen from UNICEF Finland. Thank you very much for your excellent presentation. What do you think are the most important learning points from these existing laws for the countries who are preparing this kind of legislation?
like Finland?
Like Finland.
Very good, very good. The most important learning points. Well, I think first of all, we cannot forget that we have already those international standards in place, even though if they are voluntary standards. So we have the UNGPs, we have the OECD guidances. So the law drafters should keep them in mind. They should not try to invent the wheel. You don't have to invent the wheel. You just have to establish specific, very basic parameters of human rights due diligence requirements, and then let the companies go to these standards and apply them. One thing that is important in this case, there is no one size fits all. You know, there are so many different contexts and so many different companies. So because the first point of human rights due diligence is to conduct a risk assessment, a risk mapping, the company will have to assess its own context, and then considering the context, look at the different due diligence standards that are existing. So the law should keep in mind, first, that there are these already requirements, standards existing. Second, that there are different kind of companies of all size, and you need to maybe keep this in mind when drafting the law. And third, I think the French law did something very good. That is, I didn't mention here, companies are encouraged to elaborate the plan in cooperation with the stakeholders. So this is something very good in the French law, because the companies are encouraged to speak with consumers, with trade unions, with association representatives, victims in third countries. And this is very good because this has already fostered some kind of dialogue between these different stakeholders. So that's something very good. And lately, I think companies and governments shouldn't be scared. That's something we can learn from France. So there was such a huge opposition by companies in France. You don't imagine, it's not like here. Because they were super scared, oh my God, this is gonna be impossible, I'm gonna go bankrupt. This has not happened. So companies have now published their first plans. There is no judicial enforcement yet. They are not perfect, but they have time to improve, you know? So the best lesson is don't be scared. It will not make your government go bankrupt. It's fine, it's gonna be fine.
This was actually a great introduction to our second part when we get the politicians here.
Yeah. Are there any politicians?
Some of them might be already here listening. There's another question.
Yeah, thank you. I'm Juha Berling from the Consumers Union of Finland. I just wanted to ask you, do you think the law has made a big change, a big difference? Because it sounds like it's always when the business says, yeah, this is a good law. You know, it sounds like that. Does it make a real difference? And if you know what I mean by real difference, is it just more like a paperwork, more cooperation nationally? Maybe, you know, I'm always worried about whatever kind of washing, greenwashing or whatever kind of washing. So what do you think about this?
We are also worried. Well, if you're asking about the French law, we must keep in mind that it has been in force for 1 year. So let's give, I think, governments have the first 100 days, no, as an assessment. So it has been in force in 1 year. We cannot expect magic in 1 year. So we are not going to change the world in 1 year, unfortunately. So in terms of, all human rights violations have been eliminated in the French supply chains, I'm sorry, I have to say no. But as I said, we have seen movement going on. So now, first of all, there is an awareness there. That raise awareness is one important part of also of lawmaking. Companies are aware that they cannot do nothing. So now they are starting to put the machinery into work. Consumers are more aware. So now they cannot say, oh, I didn't know, or I just don't care about what I buy. Now you have the right to know. And now you have the right to engage also with the companies to improve the situation. And civil society in general, and also associate victims in the South, in the global South, can also be more aware about the rights, because we have NGOs actively working to communicate this. So the most immediate change would be raise awareness in the overall society. And that's nothing which is, that's very important, right? And then we'll see.
Adriana Espinosa, thank you very much.
Thanks to you.
Ennen väliaikaa yksi huomio. Täällä on monta organisaatiota.